Hello, homeowners and investors. Welcome to Hooked on Real Estate. I'm your host, Sharika. On our video today, we have our very first guest on the channel, attorney at law, Mr. Deanroy Bernard, who will be taking us through the role of an attorney during real estate transactions. Before we jump into the interview, I'll ask Mr. Bernard to briefly introduce himself to the Hooked on Real Estate family.
Thank you, Lady Sharika. And first, I want to congratulate you on your new channel and indicate how privileged I feel being your first guest
Yes.
in this area. So it is certainly my pleasure to join you and indicate how proud I am to see you
Thank you.
taking on wings in this
Thank
regard.
you.
This is
Yeah,
the
thank you.
issues of matters of an attorney is very, very important in all aspects of life. But I say especially in the area that you have decided to concentrate on. It's a very important area.
Mhm.
For me, I'm an attorney at law with this year with me 13 years of practice at the bar. Um, Before that, I would have been engaged in several interfaces with the court as an investigator, a fraud investigator, a forensic accountant. So my my experience with litigation would have been, way before I started to practice as an attorney. But I've been gaining new insights since 2013 when I was called to the bar. I'm able to really, in my view, navigate this interesting area of law. This is another interesting area of law,
Mhm.
and I'm happy to share with you today. I practice in Jamaica. I'm part of the firm Ferguson Bernard and Associates. We are at 22B Old Oak Road, and yeah, matters of real estate, conveyancing, civil procedures, probate practice.
Mhm.
Those are matters that we concentrate on. Civil litigation, somewhat, um, many times where it arises upon conveyancing and probate issues. So that is me for the time being, and looking forward to your questions. I'm looking forward to give you cogent and coherent answers as best as I can.
Okay, Mr. Bernard, thank you for that. I see where you have a lot of experience. So I'm hoping that we can tap into some of that and that our audience will benefit from your expertise. So, as mentioned, persons who watch this channel are largely persons who are interested in buying whether their first home or investment properties. So, I am sure that this discussion will be beneficial to our viewers. So, Mr. Bernard, I have a list of questions that I will be looking at from time to time. So, if you see me looking down, I'm just making sure that we cover all the necessaries. So, in terms of the lawyer's role, can you explain to me, is it legal for persons purchasing property in Jamaica to hire a lawyer?
Interesting question. And you use the term legal. Is it legal to hire a lawyer? Now, any transaction between two parties or between more than one parties would be what we would call matters between them. It's private matters between them.
Mm-hmm.
And in the main, there's no legal requirement to have a third party unless one of the parties or one or more of the parties are in what we call incapacitated. For example, if a child is involved in the transaction, parental consent many times would be required, and there's always a requirement for childcare and protection in that regard. If the person is um, insane or has dementia and so forth, the capacity to contract would become an issue, and therefore, what many times we call in law an ex-friend, sometimes a lawyer,
Mm-hmm.
legal required. Um, and if at all that is not a part of the functionaries, then it can become an issue if and when that transaction is called upon to be reviewed. So whilst it is not necessary to have an attorney in all respect, there are instances where, by law, a third-party representative to protect an interest um, is important.
Okay. I think I want some clarity on that response. Um, in what sense, during a transaction, would a lawyer not be required? Could you give an example or expound on that?
Well, two persons decide that they're going to buy um, a piece of land. Since we're dealing with land.
Yes.
Now, if the parties are on the same footing, meaning that they are of this is a common man and a common woman, or a common man and a common man,
Mm-hmm.
and they go and they say that I want to sell you this piece of land from this breadfruit tree to that breadfruit tree,
Mm-hmm.
from the soursop tree to the building here, right?
Mm-hmm.
And they drop the little diagram
Mm-hmm.
and they exchange their money and they write up their little agreement and they sign
Mm-hmm.
it and they get a justice of the peace to sign
Mm-hmm.
on it. In some ways, a lawyer is not needed in that regard,
Okay.
right? It's not a requirement that a lawyer be involved in that. So that's just an example. And people
Okay.
do business every day without an attorney. You go to buy a car, you don't take a lawyer with you. So in typical contract situations,
Mm-hmm.
which you don't require a lawyer. However, and I hope I'm not jumping to your other question, the issue of land law is so technical that I would caution any person to engage in real estate matters, whether purchasing, selling, or even leasing, without getting legal advice from a competent attorney at law.
Okay. Um, as it relates to that, because I'm thinking it is a recommendation then, that when persons are conducting real estate transactions, that they seek the advice of a lawyer. In a contract where two persons are, or situation where two persons are doing, I guess it's called a common, what you call that now, a common, I'm not remembering the term, but as you explained, two persons coming together and just doing the business without an attorney. Would you suggest or recommend if persons are deciding to go ahead and do something like that or a transaction like that, that they at least seek the advice of an attorney to maybe look over contracts to ensure that their interest in that regard is being protected?
Well, I would recommend that they do that. Most certainly, I would say that it is wise to do that. And really and truly, it is foolish to do otherwise. Because many times when you enter into transactions where terms need definition, where your engagement touches and concerns legal issues,
Mm-hmm.
then it is best and wise to have an attorney at law. There are some um, some situations where you have to have an attorney. For example, if you're going to be using a mortgage as part of your purchase money,
Right.
typically it is wise to have an attorney, right? There are many pitfalls with the subject matter of land as well that only the lawyer would know. There may be issues with the title to the property. There are some properties that many properties in Jamaica are what we call unregistered land.
Mm-hmm.
So there's no title,
Mm-hmm.
right? And there are boundary issues.
Mm-hmm.
We have issues in law that we speak to call easements, right? We have prescriptions, we have caveats, we have restrictive covenants that run with land, right? So you may be buying a piece of land which you can't use, or you can't use it to the benefit that you want it to. And before you engage in that transaction, it is best to have an attorney look at how the land is situated, right? And the titles and the constraints and restraints concerning the land, right? You may think that it is just a piece of land sitting down there, you can just buy it, but it's not as sweet that you buy from the factory, right? Because land itself, it's different, and that is why you call it real
Yes.
property. You don't take it and move up and down with it as you would regard personal property. It sits there, so it is real. And there are things that what you call in law touches and concern the land, that runs with the land, and not with you, the owner, right? So even for example, if you vacate a property, right? Any person who inherits that property, the charges for water become their charge.
Yes.
It doesn't follow the person who has left. It
Yes.
stays with the land. So when you acquire the land, you acquire the debt of the water bill, which touches and concerns the land. If the person who had the land before gave permission for somebody to walk across the land, and that person walk across the land in an agreement which touches and concerns the land, it could be that when you acquire the land, you have to give access to that person, which may affect the use of the land. So land it's just a real problem. Put it this way, in courts, it's a real issue, a real problem that it is wise for you to have counsel, legal counsel, before you engage. And I say before you engage,
Before.
not during the process or after the process, because it can get very dicey when you engage during the process, because so many things could have gone wrong at the outset, which the lawyer can't fix when he comes in, he or she. And especially when the transaction has come to an end, you may find that you don't have title. You may find that you were fleeced, you were tricked. So it is important to engage with the attorney at the outset. Very important.
Okay, thank you for that point. So this leads me to my next question as it relates to at what point, I know you mentioned before. So for instance, if I'm buying a piece of land, so I saw a piece of land that I like and I'm interested in acquiring this piece of land, when do I make contact with you? Before I contact the bank, before I contact the owners, at what point do I make contact with you?
Well, your first engagement, if you're interested in buying land, if the land is being sold directly by the person who owns the land or purports to own the land, then you have to have that engagement. And as with all other contracts with land, there has to be an offer, right? And there have to be an acceptance, and there have to be consideration. And the other element is an intention to be legally bound to the terms, what we call an intention to have legal relations in regards to the transaction. So those four elements are important. And that is something that you're going to ensure that you have with the vendor, right? So the person selling you a piece of land, this is the price that they're selling you for. This is the description where the land is at, right? Right? And you are saying that based on what that offer is, I accept that I'm going to be engaged with the land, right? Now, having done that, so there's a meeting of the mind in regards to what you're buying and how much you're paying for it and who you're buying it from. Once that is in place, your next step is to consult your attorney,
Okay.
right?
Okay. Yes.
Don't go look any mortgage or anything like that without talking to your attorney. Find an attorney. The General Legal Council in Jamaica has their website of all the practicing attorneys, and I always advise persons who are seeking attorneys, whether you meet them online or in person,
Mm-hmm.
check the General Legal Council's website for the list of practicing attorneys. You put in the names, and if the person is current and up to date, the name will come up. And then usually that is a signal that you have an attorney that you can use.
Okay. You made mention of a website. Do you have the URL or
No,
where
no, I
person?
don't. But it's just
Okay.
a simple. The General
So once we type that
Legal
in, it
Council
will
of
pop up.
Jamaica, right? The
Okay.
GLC, what we call the GLC, right?
GLC.
The
Okay.
GLC. So, and you go there, there's the list of practicing attorneys, and each year the attorney has to renew his license.
So
And
if you type a person's name and it's not there,
that person is not practicing, should not be practicing an attorney.
okay. Thank
And
you
what
for that,
it is unlawful
for
for
them
that
to practice.
to carry out the practice of law without a practicing certificate.
Okay. You made mention of a number of things, the offer, the acceptance, the consideration. I think those were clear and you did give some explanation. So I don't think we need to go through that. But in terms of piece of land or property, in terms of a title search and ensuring that the land is fit for use, can you walk us through an example of that? How do you go about doing like a title search to ensure that all things are okay before
Right.
yes.
Right. So there are two typical pieces of legislation that govern land in Jamaica, right? The Registration of Titles Act and the Conveyancing Act. Now, as I said, our land system in Jamaica um, came to us from our colonial masters. And you will hear about the torrent system. I don't wish to go into it any further than to say that we are practicing a system that we got from our masters. And sometimes it is not the best system, but as it is what we have.
Mm-hmm.
It is what we have. Now, so with registered land, there is a land registry in Jamaica, which we refer to as the titles office,
Mm-hmm.
right? And of course, a title search is done there. Now that is at the Hanover Street. I'm trying to remember the number. I don't remember if it is 90. I think it is 90
Okay.
Hanover Street,
Mm-hmm.
where any person can go there and with the name and the description of the property or the address, you can complete the form. If you don't have the volume and folio number, you pay $800 to do a search. If you have the volume and folio number, you pay $500 to do a search. And what they would do is to give you the title to that land, if the land is registered, right?
Mm-hmm.
And that title would show you who are the owners and the history of ownership. Show you where there's a mortgage. Sometimes it shows if there's a caveat. Sometimes it will always show you what are the covenants on the face of the title. So it will tell you if you can build your fence at a certain height.
Mm-hmm.
It will tell you if you can subdivide the land. It tells you how the water will run. So it tells you all these things. So it's a good first step to have a copy of the title. Now, the face of the title doesn't tell you everything about the land, because there may be attachments to the land, even in the registration system that do not appear on the face of the land. So it is important to apply for what you call a search certificate, So you can search for everything that is in the registry concerning the land. It is also important to know whether or not the land is registered by an estimation, meaning that the land is registered by an estimate of the size of the land, or whether the land is registered by what we call a plan, a diagram, which a commissioned land surveyor would have done, gone to the area and done measurements and put in a pre-check plan, and that plan would have been approved and attached to the title. The safest thing always is to ensure that the property that you're buying is registered by a plan. And in doing that, you avoid some land disputes that you may have otherwise. But it is always important even then to get a current survey of your land, because you may have a diagram and a report that suggests that all the boundaries are clear and nobody's encroaching. But since 5 years ago or 6 years ago, somebody built something and encroaches on the boundary. So it's important to have a current surveyor's ID report. And many times mortgage companies, for example, will not use a report that is older than a year. That is how fluid it is. So you go to the land system and you do your search, and you have your title information about the land. You will know if the person who is selling you the land is the actual owner. Because there are persons who inherit land. The land has not been transferred into their names, but it's there. They say it's their land, and they're selling the land, right? But if you are not the legal owner of the land, you have to take some steps before you can sell that land. You can't just sell the land like that. And of course, you have the conveyance act that deals with lands which are not registered, right? And the best thing to do is to move unregistered land into the registration system.
Mm-hmm.
And the system makes provision for an application to be done to bring land under the Registration of Titles Act. So that is a first step that I would ask any person who is buying land that is unregistered, right, to do. To try to get the land under the Registration of Titles Act, because that means that you can walk away feeling better that you own this land. Because just imagine 4 or 5 persons can claim ownership of unregistered land, and an individual can sell different persons the same parcel of land, because there's no registration of ownership system. It is very important that if you're looking at unregistered land, that you try to bring it under the registration system.
Okay.
Some people don't, but it is better to do that. And
Okay.
many times unregistered land, it is transferred and sold by what you call a deed.
Mm-hmm.
Right? Person leaves with his deed, he owns the land. Right? He can convey that deed, he can deliver that deed and move the land from different parties. So, which makes it so risky to be buying land under that system. It is best to move to the registration system.
Okay, Mr. Bernard, I'm happy you touched on that, because I've done some research that states that over 50% of lands in Jamaica are unregistered. You made mention of having a deed. Some persons may have a deed in lieu of a title. How difficult is it for someone who does not have a title, but they have a deed, to go through that official registration process?
Well, and as I said, it's going to be difficult for the person who's not trained, a trained attorney. But for attorneys, it is not difficult. It's what we do every day. Right? So the deed is your first claim of ownership of the land. So you're an owner in possession, and the deed gives you what you call an equitable interest in the land. Now you're going to now formalize that equitable interest into what we call a legal interest.
Mm-hmm.
And to do that, you engage the process. So your deed um, is supported by an instrument of transfer, or in the case where it's a case where you have held that land for over a period of time,
Mm-hmm.
can make the application and show the registrar what we call a root of title, to show the history of what came into your possession and the fact that you have paid valuable consideration for the land, and you now have a deed. But it is now upon the registrar,
Mm-hmm.
right, to issue a title based on your application and based on your supporting deed and any other documents that the registrar may deem as necessary to have. Maybe sometimes registrars want receipts to show that monies have passed.
Mm-hmm.
The deed, of course, is important, right? And typically, it's not a difficult situation,
In
right?
terms of timeline, so if I have a piece of property now and I don't have a title, but I have the deed, and I approach you to start that process and get that ball rolling, how long would it take from contact with you to have that process
Well,
completed?
it's hard to estimate,
Mm-hmm.
right? But I would say within a year.
Within a year.
Yes, I would say within a year. And there is an expedition system in the title office, but it costs a little bit more. Some clients are willing to pay, some are not willing to pay. But I would say within a year.
Okay, so with that expedition, I'm thinking that timeline would be about how much? Half of that
Well,
time? 6 months?
it can be a month, 2 months, sometimes shorter. It depends on the complications.
Mm-hmm.
But there is that a facility that you pay for. Right. To bring title on the registration to bring land under the registration of Titles Act involve advertising the so you see in the Sunday Gleaner, especially these legal notices,
Yes.
right? Those are notices to the world that I'm seeking to acquire title for this property, and for any person with an objection to come forward. Typically, that is 2 weekly publications, and then you have to wait 6 weeks after that to be able to submit the advertising clippings to the titles office before you can move ahead in the process. So even though um, they try to be quick, there are some things that the registrar doesn't have control over,
Mm-hmm.
right? And the law requires that persons are notified before you can bring land under the Registration of Titles Act.
Okay.
Because
So,
as I said, in the conveyancing system,
yes.
there could be many persons with claim to the same piece of land.
Yes. Okay. So that means for persons who are interested in getting that process correct, getting the title in their name, contact your lawyer. That process, as you said, can take up to a year. If they're willing to pay the extra money to have it expedited, it can be done in a shorter period of time. And that
Yes.
goes for persons who have inherited land, or is that a different
No,
process?
no, 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 no. That's a different practice.
Okay.
Inherited land many times, and then it is dependent on how the land was inherited.
Okay. Well, let's use the example. My
Right,
parents passed and the land was willed to me, but it's not in my name.
right. So in that case, you have an issue of probate.
Okay.
So you have to have a grant of probate where there's a will to have that land move to your name. So the first thing that you'd have to do is to get an attorney to approach the court and file certain documents, including an oath, right? And if there are other parties, you have to get their consent. If there are other parties to the will, you have to get their consent. And that process again can take 6 months to a year. So you are now in court, um, and you file these documents, and once you get your grant of probate, you now have to go and look at the estate duties. You have to look at transfer tax on the estate. The estate has to get to be assigned a TRN. And that only then can you now go and register what we call on transmission your name to that title. And then you can deal with the title and the property thereafter. But before that, you cannot meddle with the estate. You should not meddle with the estate because
Ah,
there's actually a law that forbids meddling. And the law sets out how matters under wills are dealt with. There's actually a Wills Act, right? That deals with how wills are to be dealt with, and how wills are to be executed upon the death of a person. So those areas are controlled areas. So you can't do as you please to go sell land because it was willed to you and all of that.
okay, thanks for that, Mr. Bernard. As you're speaking, reflecting on a personal experience. I know someone who is in that position, and it has been that way for quite a number of years. Her father passed, and the father, via a will, left a piece of his property for her. But as far as I'm concerned, and as far as I know, she did not do anything since then, because I guess it's assumed that once your name is on the will, this is your property and you don't need to do anything else. So can you just briefly walk us through what grant of probate process is like, and what do persons do to ensure that they're acting in the right and proper way? Because I don't think a lot of persons are aware that they need to do all of this.
Yes, yes, definitely. If a property in a will usually comes with what you call executors. So for a will to be effective, it must have at least one executor.
Mm-hmm.
Some wills have two executors, some have three. All right, but in the case of the executor is the one who is supposed to gather all the property under the estate
Mm-hmm.
and distribute them. Now, the permission for the executor to do that comes from the court in what we call a grant of probate. Now, to apply for that, the executor first must be able to estimate the value of the estate. That's an estimate is required. The executor must be able to be somebody of capacity, a sane person, not typically an infant,
Mm-hmm.
right? And somebody appointed in the will as the executor. Now, that person would declare what we call an oath. An oath,
Mm-hmm.
right? So it's an oath of executor or executrix. If it's a female, it's an executrix. It's a male, an executor.
Mm-hmm.
That document will be prepared by the attorney after interviews with the executor.
Mm-hmm.
The executor signs, and the JP adjusts of the peace witnesses the signature,
Mm-hmm.
right? And that is placed along with a draft of the grant of probate before the court, right? Now, the oath has to be stamped at the stamp office. So you have to pay $5,000 to stamp it typically at the stamp office. And you will take that oath along with the grant, the draft grant.
Mm-hmm.
If it is that the estate has taken years to be probated, then you have to give the court a reason as to why you did not probate the will earlier. And so you have to issue what you call an affidavit of delay, right? Which tells the court why you took so long to come before the court with this matter.
Is
the will also, the will, sometimes when you hold will too long, the will gets, gets stuttered and you can't see things and so forth. Sometimes you can't find the witnesses because every will must have at least two witnesses who must sign before the person who is what we call the testator. So the person who is giving the will, giving estate his property under will, must sign before at least two witnesses. And interestingly, any person who is a witness to the will cannot be a beneficiary. It's
mm-hmm,
very important for people to know that, right?
mm-hmm,
Some people just gotta get the man is sick, you just hold him up and say, all right, sign a will. I'll
mm-hmm,
witness it.
mm-hmm.
But put me in it to get all the property. No, the will fail because those who are witnesses cannot be beneficiaries. Right? But an executor can be a beneficiary, but a witness cannot be a beneficiary. Right? So you do that, and I'm saying that if the will is stuttered, you have to do prepare another document called an affidavit of due execution, also signed by JP, right? Indicating some things about the will to give the court the the comfort that this is a valid will.
Okay,
And
that's a lot to take in,
yes,
a lot to digest. I'm gonna try and see if I can break it down. So in the case of delay, I know you mentioned, is it called an affidavit of delay? That's a term you
an
use.
affidavit of urgency or delay.
Okay, so in the
Right?
case
But
of
in the case of the will not being probated
probated,
for years after the
yes,
person's death, it's
yes,
really you're explaining the delay.
yes,
Right? Sometimes you're explaining the urgency,
yes.
the process of probating the will is it is very important and it involves affidavits,
Mm-hmm.
it involves oaths, and it involves a draft grant. And the attorney will file that along with the original will and an original of the death certificate. Now, the will has to be marked. The marking of the will, there's a marking clause that has to be written on the will to indicate that the paper writing that is before the court contains the last will and testament of the testator who died on whatever date. Right? It's very important that the oath states the all the information correctly of the person who has died.
Mm-hmm.
And many times it's important that the oath speaks to all the different names that the person who has died has used.
Hmm, interesting.
Yes, because the oath may have Sharika Wilson,
Mm-hmm.
but you may have property in Dawn Wilson
Wow. Mm-hmm.
because people change their names and they have deed poll and so forth.
Mm-hmm.
It's
Mm-hmm.
important that the attorney asks what other names were
Mm-hmm.
used. And sometimes people use their middle names and title, and some titles sometimes they don't.
Wow.
So all those names have to be in the oath and in the draft grant.
Mm-hmm.
Because if the grant comes back with Sharika Wilson and there's a property in Dawn Wilson,
Mm-hmm.
the registrar is not going to allow you to deal with that property
Wow.
with that oath.
Mm-hmm.
But
Mm-hmm.
if the oath and the grant mentions the other names,
Mm-hmm.
right, then it is much easier. I had a client which had about six properties,
Mm-hmm.
all in different version of his name. Some names he dropped off the E, some names he kept it, some names he used his middle name.
But how is that allowed though? Because I'm thinking then when you're purchasing properties, whether via cash or mortgages, you have to provide your identification, your IDs. So How is that
There's
possible?
a time, there's a time when we never had IDs and TRN,
Oh,
right?
okay. So these are older persons, older
Typically older
properties.
person.
Oh, okay.
And the other one is the older person that died typically.
Mm-hmm. Well, that's true. That's
You're
true.
gonna run into those kind of issues.
Mm-hmm.
It's important that the attorney um and as all those variations.
Mm-hmm.
And of course, if the executor is abroad
Mm-hmm.
and is signing an oath, there is a requirement for the commission, the commissioned notary public
Mm-hmm.
to sign and also present a certificate of his or her commission, because the court is not going to accept the oath or any affidavit without that, where it is signed abroad.
On the
And
mat.
when I say abroad, I don't mean a Commonwealth country.
Mm-hmm.
Commonwealth country, it's different. Like if it's in the UK or Canada, they can sign out this commission certificate. But if it's the United States, where many Jamaicans are,
Yes.
then it requires a commission certificate. And the commission certificate is usually issued by the state or the city.
Mm-hmm.
So all of that, those are some of the reasons that you need to have an attorney, because
Yes.
those are pitfalls that you can find yourself in
Mm-hmm.
and not have proper legal counsel to assist you.
On the matter of an executor, who is the best suited person to serve as an executor? Would it be a family or a friend? Because I know you mentioned that an executor can have parts in a will. So in terms of protecting one's best interest, who would you suggest that persons consider when selecting an executor? Select from this category of persons.
But the first thing in selecting an executor is the issue of trust.
Mm-hmm.
Is this someone that you trust that is going to act in the interest of your beneficiaries and by extension in your interest? That person is going to step into your shoes when you pass. And like it or not, all of us will pass one day. So you want that person to be a person who is conscientious and a person who can deal with disputes, right? Because many times after you're gone, the hatred that people have for each other comes up. They mask them while you're alive, but when you die,
You see all of their true
sometimes
colors.
hate you.
Yes,
And they
yes.
fight over what we call in Jamaica
Dead
deadlift.
left. Mm-hmm.
Sometimes even before your body goes under,
Mm-hmm.
first thing people are trying to do is
Mm-hmm.
to get something from your death, right? So you want somebody who's going to be confidential too,
Mm-hmm.
because not everything in a person's will he or she wants to be shared publicly, right? For the person, it's important that the person is confidential and not scandalous. There are times too when persons have more than one families
Mm-hmm.
in, you know, that atmosphere.
Yes, yes.
Yes. And the person would want somebody from the other family to inherit, right?
Mm-hmm.
So the executor is a trustee for that person, right? So the issue of trust and fiduciary responsibility is something that you have to gauge when you decide to take on an executor. And typically, I would tell persons not to use executors that are older or much older than them.
Mm.
So when your executor die before you, you're going to have to change your will,
Mm-hmm.
typically.
Oh, so once an executor passed, you have to change the will.
If you have one, but if you have more than one, you can continue with the one that is alive, but once it pass. All right?
I have a follow-up question on the matter of wills and passing on of property. Can someone transfer properties while still alive? If
Oh, yeah.
yes, what's the process like?
Oh, yes. So, we went from what we call interview was transfers,
Mm-hmm.
that is transfers while persons are alive, into what we call testamentary transfers.
Mm-hmm.
It's transfers after a person has died.
Mm-hmm.
So we went to wills,
Yes.
which is testamentary.
Mm-hmm.
But interview was is when we are at the live state, live being transferring property.
Mm-hmm.
And definitely you can transfer property while you're alive.
Mm-hmm.
Once you own the property, ownership is important because you cannot and should not be transferring property that you don't own, right? Yes, unless you have a power of attorney given to you by the person who owns the property, right? Or a
Mm-hmm.
court has given an order for a property to be transferred. Typically, it is the owner or owners who are entitled to transfer properties. And that can be done certainly while you're alive.
Mm-hmm. And I'm thinking that's an easier process, correct? Instead of you wouldn't have to go through probates and stuff
No,
like
man,
that.
the probate process kicks in when you're dead.
Right. So what's the process transferring
But you may
whilst
want
you're
to enjoy
alive?
your property while you're alive. So you enjoy it when you're dead and you go to med rest.
Mm-hmm.
Other people go and rest on it, on your property that you leave behind. So that happens under the probate system. So if we come back to interview transfers, um, the the transfer is easier because no court gets involved. So it's just you
Mm-hmm.
say where you want to transfer the property to. Much easier process. Government of Jamaica has done well in reducing the transfer tax.
Mm-hmm.
You don't have to pay any estate duties. You just pay your transfer tax and your stamp duty. Transfer tax is typically 2% of the value as assessed by the stamp office. So you could be selling your property for 10 million, but the stamp office, when they go to value it, they say it's value 20.
Mm-hmm.
And they charge the stamp duty on 20 and not 10. So you can't run from the duty by putting on a paper that you're transferring for 10 million. Right?
Mm-hmm.
Because they're going to typically assess it. Sometimes they assess, sometimes they don't. Sometimes they typically know what the market values are, and they would apply the tax based on that. But it's typically 2% of the value. Sometimes they use a consideration, that is the price that is being sold for.
Mm-hmm.
Sometimes they use their own valuation.
Mm-hmm.
Stamp duty is fixed at $5,000 for land matters.
Mm-hmm.
So you don't have to do a valuation for that, right?
Mm-hmm.
And of course, you have your registration fees, 0.5%, which is paid to the registrar to move the title into your name. You have other fees, you have your legal fees. If you're using a realtor, your realtor has a percentage of the sale price that the vendor pays him or her, right? And there are also fees for the possession letters. Because at the end of the process, you need to be able to get your name on the tax roll so you can start paying property tax on your land,
Mm-hmm.
right? You need to get the water transferred to your name. And the water, as I said before, runs with the
With the
property,
land. Mm-hmm.
right? And then, of course, electricity. Um, so you need those letters from the attorney,
Mm-hmm.
which authenticates you as the owner.
Mm-hmm.
And then you can go and enjoy your property after you have purchased it.
What happens, or before I even get to that question, in terms of wills, what can cause a will to be void?
Also, you're going back to
Yes.
dead people
Yeah.
transfers.
Yes.
Right? So we're finished with live people transfers.
Yes.
Let
I
me.
think
All right. So what can cause a will to be void?
yes.
Well, wills can be void if they don't follow formalities.
Mm-hmm.
Right? Good. Wills can be void if you don't have two witnesses.
Mm-hmm.
and that the two witnesses did not sign before before the testator. They didn't see the testator signing. Testator mean the person who gave the will
Mm-hmm.
and is now dead.
Mm-hmm.
Right? So the witnesses must see the person signing and witness that they have seen the person sign the will. So a will can fail if you don't have two witnesses. It can, I say it doesn't have to because there are ways that you can give evidence and so forth in court, and the court can accept a will to prove it. But typically, the formalities require two witnesses, and the will fail um, if those are not there. The will fail if the witnesses are beneficiaries, right?
Mm-hmm.
A will can fail if the property being gifted are not certain. Right?
Explain. What do you mean?
So,
Not
for
certain.
example, I will my car, which is parked in Yala St. Thomas.
Mm-hmm.
I put that in a will,
Mm-hmm.
right? Good. Now, at the time the man is dead, there may be no car parked in St. Thomas, right?
Mm-hmm.
So there's no asset to find. So it's not definite, it's not certain as to the asset that you're gifting,
So in
right?
the terms of real estate, it could be a wrong address
Well,
in that case.
it could be a misidentification, it could be a wrong address, right? And the identification of the property may be such that it creates uncertainty,
Hmm.
right? Good.
So it's not
So
from the mango tree to the guango tree, but it's from the guango tree to the apple tree.
right. So there's uncertainty, which can create
Yeah.
disputes and create uncertainty. So the will can fail in that regard. Sometimes wills do not fail fully, but if a will is disinheriting certain persons that are vulnerable,
Mm-hmm.
then the will be challenged, can be challenged in that regard. For example, a will that disinherits a minor who's dependent on the father, right, can fail in relation to the gift of the assets in that will, because the court can step in to ensure that that minor is protected. If that minor depends on their father for school and education, the father dies, and there's nothing in the will for that minor, right? Or even a wife who's dependent on her husband, right? And some smart person decide to get him to sign a will to disinherit his wife. Then the court can step in, right?
But what if the husband deliberately did not want to leave anything for the wife in a case, or a
Well,
wife?
the law said no. If the wife is dependent on you, right?
Mm.
She's there looking after your home and dependent on you, and you would die, and your death now creates hardship on her, and you leave all these assets in a will to a sweetheart
To
or to your
children.
friend.
Mm-hmm.
So that wife can challenge that will. There's a family dependence legislation that intervenes there to protect the wife and the minors in that regard. So in that sense, the will fails,
Mm-hmm.
right? The will fails too if the will is if there's any evidence that the will was revoked, right? So the person who gave the will wrote something else to say that I no longer that will has been revoked, and somebody else has a document. We call it in law some kind of codicil or republication of the will. That will fails,
Mm.
right? Because that will has been revoked, right? Sometimes a person may just tear the will to revoke it, just tear it up, or just tatter it in a way that it cannot be, it becomes unreadable, right? So people can do that. So in such senses, the will fail. And then in wills, you have properties that are current. There needs to be typically what you call a residuary clause in wills. A residuary clause is a clause that catches all properties that the person may acquire after the date of the will,
Mm.
or properties that the persons were not sure of or know exist at the time of making the will. And then the provision needs to be made as to who should get those properties. If there's no provision in the will for that, then the will fail in that regard. Right? And typically when a will fails, the property goes into what we call intestacy.
Mm. That's
Right?
the law takes over.
So another law takes over. Because when you deal with a will, you are under a law, you know.
Mm-hmm.
But people don't understand that when you're dealing with wills, you are actually under a law.
Mm.
So the law is operating with regards to wills. But when the will fails, it moves into another law called the Intestates, Estates, and Property Charges Act that will now treat you as dying without a will. And that becomes a whole complication. We don't have time for that today.
Mm-hmm. Mm-hmm.
But you don't want to get there. It is best for persons to make a will. Yes.
Yes. Wow. That's a lot. Oh, and I needed to ask this question too. I think I was having a conversation with a colleague, and he mentioned as well that once you get married, you're supposed to update your will. Is that true?
Yes. Your will typically, if you make a will before marriage, upon the date that you got married, that will is extinguished. The will dies.
Explain.
Well, that's just the law.
Hmm.
Yes, that's just the law. So you have to republish your will or create another will for that will to stand.
Mm-hmm. With a new date,
Yes.
post-marriage.
And that's why I say that marriage is honorable in all
Yes.
and can destroy a will, right? So a girlfriend may inherit under a will and then the man gets married. That will doesn't no longer subsist.
Mm.
And that girlfriend is walking up and down with her will and say, oh, he married, but he's me have the property. Not
Mm-hmm.
so, right? He
Mm-hmm.
needs now to create another will
Mm-hmm.
if he wants the girlfriend to inherit post-marriage. Right? And I can see the wife being very interested in that he would go and do that. Right? So it is a fact, and counsel was right when he indicated that to you.
Yes. So can a person have more than one will?
The wills that speak to the last will and testament.
Last will.
Right? So if there are more than one wills, the latter one takes over.
Mm-hmm.
The both can't subsist.
Mm-hmm.
There's a last will and testament.
Mm-hmm.
Typically, in a will, there's a clause that says, I revoke all other wills and testaments.
Mm-hmm.
There's one of the first clause, I revoke all other wills and
So
testaments.
it's the last one standing.
Last one that stands, yes.
All right. Thanks for that clarity. Earlier you mentioned offer acceptance consideration. I think that kind
You're
of
back into
sums.
you're back into interviewers now.
Yes. So I think that kind of speak well, at least for me, I think that's speaking to sales agreement and stuff like that when you have that formal contract. What are some things that persons need to be mindful of when looking through a
Well,
sales
well,
agreement?
well, it is good that you mentioned that because the system that we run under also recognizes a law that we call the statute of frauds.
Mm-hmm.
And the statute of frauds say that certain transaction must be in writing. And the sale of land, any agreement for the sale of land, for it to be enforceable, it must be in writing and signed by what we call the person to be charged, right? So the person who bears the burden of giving that land must also sign it, right?
Mm-hmm.
So the agreement for sale is a written document that is required in Jamaica for you to enforce your interest in land, typically. And I said typically because sometimes a court can invoke an agreement even without a written agreement where there is some paper writing, for example, a receipt.
Mm-hmm.
So I give you $800,000 for this piece of land. The land is identified on the receipt, right, as volume and folio X, address X, but there's no agreement for sale. That person dies, who sold me the land dies, and his beneficiaries want to know, say, no, we're not recognizing the sale, right? You have a document that shows that you have an interest in that land.
Mm-hmm.
And that interest, the law is going to recognize that interest, even though there's no written agreement, right? But the important thing, very important, is that you have the agreement for sale, because the agreement for sale sets out all the clauses that are important to prevent or mitigate disputes in the land conveyancing process. Right? I have a case, which is a live case even now, where the gentleman sold the land for a price. The agreement for sale stated the price. Both parties signed agreement for sale, right? Then he learned that a valuation was done on the land by the government and that the value was twice what he was selling it for.
Mm-hmm.
And he decided, said, no, 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 I'm not going to sell for this price again.
Mm-hmm.
Now the purchaser is saying, no, you can't do that. We have a contract
Mm-hmm.
and you must follow through the contract. Right? I
Mm-hmm.
would say no more about it because it's a matter that has to be tested.
Mm-hmm.
But we believe that the courts will look to the agreement, the terms of the agreement, which is the case law on the point.
Mm-hmm.
Once the terms of the agreement are not ambiguous,
Mm-hmm.
right? Then the court is going to enforce the terms of the agreement. And so it is important that you first have an agreement for sale and that the terms are clear and certain. The minds of the parties expressly must be expressed in the contract with clarity, without ambiguity, and without confusion.
Mm.
That is the importance of an agreement for sale. Right? Agreement for sale, as I said, sets out the parties' names, their occupation. It's important that the TRN is stated. Right? The purchase
Mm-hmm.
price is important. The completion dates, because in real estate matters many times becomes of the essence,
Mm-hmm.
right? And if time passes, there can be interest that attracts to the outstanding sums, right? There can
Mm-hmm.
be interest attached to the purchase, to the deposit, right? They are what we call forfeiture clauses that
Mm-hmm.
can see the deposit being forfeited. There's a whole case that every lawyer at Norman Manley Law School knows,
Mm-hmm.
right? Doge Upon Workers Bank, I wouldn't bore you about that right here,
Yes.
but it speaks to how deposits are dealt with,
Mm-hmm.
right? Especially, and also there's a mortgage, and the purchase, the sale is contingent on the person getting a mortgage. If that clause is there, that's an important clause to note,
Mm-hmm.
right? And very importantly, the the issue of the commission of land. As I said before, the commission of land may value the property at a higher price than the purchase price. What do you do in that regard? That must be outlined, stated in the agreement for sale. Right? I'm trying to make sure that I'm not leaving out anything.
Yes.
Typically, the lawyers acting for the vendors for the vendor and the purchasers
Mm-hmm.
are in the agreement,
Mm-hmm.
that the parties consent that Sharika is representing the purchaser and Mr. Bernard is representing the vendor. All of that is stated, right?
Mm-hmm.
Some agreement for sale have the parties consenting to the payment of the realtor's fees, right? Some lawyers don't like to put it in there. Some lawyers do. You know, I always try to protect the realtor because the realtor works hard and should be paid. But some lawyers, so I include it typically, but some lawyers do not include it. So those are terms that are very, very, very important for an agreement for sale, and pay special attention to what we call the special conditions, because there's where the pitfalls are. So if I'm reviewing an agreement for sale on behalf of a purchaser, especially, I am looking to protect the interests of my client from interest. So typically, I'm going to negotiate the interest rate. So if the interest is 8% or 10%, I'm trying to get it down to 4% to 6%. Sometimes they'll agree, sometimes they will not. Time to complete is also important for me. So if I'm getting a mortgage from NHT, I know that that's going to be longer than getting it from a bank. If the bank is typically 90 days, I'm going to want 120 days, sometimes 180 days in the contract. And that will help me from not paying interest if time runs on me. I'm avoiding forfeiture clauses, right? If the person insists, I try to negotiate. Maybe a forfeit half or a quarter and not the full sum. Right? What else I'm trying to do now? Of course, I'm trying to ensure that the description of the property is as it is on the agreement on the title. So I can't just come up with a description, put it in an agreement for sale. It must be in accordance with the title. Right? And then there's our issue of possession. Right? Is possession vacant? Or is it that the person is buying the property with people on it? Because sometimes you can complete a transaction and you can't give vacant possession. And therefore you can't collect the money from the purchaser because the purchaser cannot get access to the land because they may be squatters on the land. That becomes a whole issue if they are squatters on the land, especially if they are claiming the land under adverse possession. So quite a number of issues in that regard. And
Wow.
all of that must be contemplated in the agreement for sale.
So I think you kind of touched on my next question I wanted to ask. When a property is valued, for example, in the example that you gave, higher or lower, and what happens if a purchaser tries to back out of a transaction? What happens then?
Well, as I said, the agreement for sale would always try to contemplate how that is treated. So if the property is valued higher than the purchase price, that's a benefit for the purchaser, right? Because the purchaser should see that that I'm getting my bang for the buck.
Yes, equity.
But it comes with a cost because the stamp duty is transfer tax is no
Percentage.
longer on the purchase consideration, value. Now, the parties can agree that whatever difference they shared equally. Let us say the additional transfer tax is $10,000. Split in half. It can be agreed that we split in half. You can agree that the purchaser pays all of it. Right? But typically the vendor is not going to pay all of it because it's a benefit to the purchaser. You follow me?
Yes.
Right. So that is how you deal with that. If the purchaser decides that he wants to back out, typically is a rescission clause where the parties will go back to their status as if they never contracted. It will be returned, right? And everybody goes their merry way.
Yes.
And now feels good because you realize that this property is worth more than he was selling it for.
Yes.
And the purchaser gets back his already deposit and is feeling good about himself. They go and buy something else. Because sometimes it is better to back out of a deal than to have a dispute. Take you into the courts.
But in a case like that, doesn't the purchaser stand to lose their deposits?
If there's a forfeiture clause, right? If there's a forfeiture clause, because remember, that, and I don't want to have to go into the whole, um, legalese on contract law, right? But the important thing about a contract is the meeting of the minds. What is it that the parties considered when they were making this agreement? Many times they were not contemplating or considering that property would be valued more than what they are thinking of, right? So it would not be fair to enforce a penalty on either party in that regard. However, if it is expressed in the contract, right, the party who suffers the loss. For example, if the person is backing out, the vendor can enforce the forfeiture clause, right, and forfeit the deposit, right? But typically it has to be expressed. It cannot be something that just come behind the person and just say that, oh, the value is above 10 million. You say you're not going to pay the transfer tax. I'm going to take a deposit. No, you can't do that.
So that is something that's normally considered, discussed between client and attorney upon creating that contract, correct?
Every lawyer who's dealing with conveyancing matters must contemplate the possibility that the value of the land. Because sometimes a client will say, I'm buying a property for $10,000. Let me say $1 million. I'm going to find my 10%, which is 100,000. I'm going to go to the bank for 90, for 900,000. I have no other money. Just my $100,000 plus my fees, right? When I go to I pay my $100,000 deposit, I have my agreement for sale. I go to the bank and the bank say, oh, we are going to appoint a valuator to value your property. They go and file the property and the property value 800,000. So the bank is now going to give you 90% of $800,000. Right? Right? Which is
Yes.
what, $720,000. So you have a shortfall of $180,000. You have no more money. So you find that there's a problem right there.
Yes.
Right? So it is always important to contemplate.
So that could be one reason a transaction may fall.
We were speaking to the issues concerning the agreement for sale.
Right, and the shortfall.
And the shortfalls we spoke to where the valuation would be different from the purchase consideration. If the purchase is depending on a mortgage, then there may be a shortfall because the financial institution typically is going to give you the percentage of the lower of the purchase price or the valuation. So in that sense, a real estate transaction can fall through if there's no support for that difference. There are other possibilities. The one party may change his or her mind, and in the agreement for sale, sometimes there is provision for what we call force majeure. All right, the subject matter, for example, can be destroyed. Let us say you're purchasing a house and you're well into the transaction, and then here comes Hurricane Melissa and destroy the house. The agreement is frustrated. What we would call an act of God. And then the contract would more than likely be rescinded. So each party returns to his or her own earlier position. That's another way the subject matter can fail. There could be fraud in the inducement or fraud in the execution, as we call it, where one party really doesn't have anything to sell, right? Or the lawyer on the purchaser side may realize that there's something wrong with the title. So the title is not a bona fide title, and the person who is claiming to be the owner is not a bona fide owner. Persons enter into transactions as vendors, but the title does not bear their name, right? And the truth of the matter is that it is very important that if there is suspicion of fraud, that be dealt with very early, because once the title is transferred, any purchaser who purchased that property without notice of the fraud becomes a legal title holder and takes ahead of the person who is the true owner of the property. So there's always the issue that the lawyers have to look out for fraud, and a transaction may fail because of that.
So in a case like that, of fraud, and if the purchaser already paid a deposit, um, will that person forfeit that? Would they lose that money?
Um, typically no,
Okay.
typically no, and that is why it is important to have a lawyer, because where two parties are in a transaction like that,
Mm-hmm.
without an attorney, the purchaser typically will be paying the deposit to the vendor. Now, if the vendor is a scammer,
Mm-hmm.
that money gone.
Mm-hmm.
But if the deposit is paid to the lawyer, and it turns out that the vendor is a scammer, that lawyer holds the deposit as a trustee
Mm-hmm.
or the depositor or the purchaser,
Mm-hmm.
as a duty to return the deposit to the purchaser in cases where the transaction has failed. Of course, typically the agreement of sale will say that the deposit is returned less the legal fees for,
Okay.
for the lawyer, because the vendor's attorney typically prepares the sale agreement, and there is a cost, what we call half cost. So there's a flat fee, let's say, typically about $90,000 to $150,000. Some lawyers are at 150, some are at $200,000. Depends on the years of experience and notoriety of the lawyer.
Mm-hmm.
So in a case where there is fraud, the lawyer will return the deposit, and they'll be in the agreement that a portion will be withheld for legal fees for work done by the lawyers.
Okay.
Typically, you'll have that. But I can't see a case where a lawyer has the funds, there's a fraud by his client, the vendor, and he retains the money and give it to the vendor. Now, I've seen where lawyers are asked by the vendors to give them part of the deposit because they run on hard times. Now, I'm not advising attorneys, nor am I giving any kind of legal advice. I'm just speaking to matters that I would have encountered. Never you give the client the funds. You have a duty as counsel, a fiduciary duty to the transaction, especially if you're the lawyer with the carriage of sale.
Mm-hmm.
You have a duty to carry the sale toward its completion. And even though you represent the vendor, right, there is a fiduciary duty that you also have, and a professional duty in relation to how you act with funds that are committed to your hand and to your trust. And many attorneys, they lose their practicing their license, they are disbarred for client funds. So the easiest way to lose your practice by being covetous for client funds.
Hmm. Interesting to know that. And I just wanted to clarify for those who may not know, deposits are generally paid to the lawyer, correct?
Well,
And these are
deposits are to be paid to the lawyer.
right.
Sometimes the agreement could be that there's a bank account that is open at a bank
Mhm.
and the money is put into escrow. So there are varying ways to pay deposits.
Okay.
But in the main, the attorney holds as trustee until the process is completed. And that is why it's very important that the attorney that you use is one of integrity.
And you mentioned earlier, was it the GEC to ensure that the
GLC.
GLC to ensure
G,
that
G for
person
general,
mm,
L for legal,
legal and
and C
counsel.
for counsel.
Correct. Thank you for that
Right
clarification. So
there at right on Harbour Street. I'm not even remembering
the
the
number.
the number, but they're right beside the Air Jamaica building.
Mm.
Right,
So it's advisable that persons ensure that they avoid these costly mistakes by checking and
right.
ensure that their lawyers are within.
Another pitfall I would guard, purchasers, vendors, parties to a transaction not to do is for both vendor and purchaser to share the same attorney,
Mhm.
because that creates in law what we call a conflict of interest. The parties, even though they are cooperating to purchase and sell property, by implication they are adverse,
Mm.
and therefore one lawyer should not be representing both. Now, I had a situation once where the client was a vendor.
Mm-hmm.
Well, one part was a vendor. I was representing the purchaser.
Mm-hmm.
We had gone some way in the transaction, and the vendor's attorney and the vendor had some issues. So in a sense, the vendor's attorney withdrew himself from the transaction, and the vendor was now left with an attorney.
Mm-hmm.
Now the vendor was saying that I don't have an attorney. I do not want to continue with this matter. In the interest of my client, I said to the vendor, okay, I will complete the transaction, but I'm not acting for you.
Mm-hmm.
I'm acting for my client who is a purchaser, but I'm going to complete the sale because I have a fiduciary duty to my client, the purchaser,
Mm-hmm.
to ensure that proper title is delivered to him. Right?
Mm-hmm.
Now, in that case, it could be said that I'm representing both, but I'm not, because I don't have a retainer agreement with the vendor, but I'm taking on the carriage of sale duties that the other lawyer was doing and is no longer doing. I'm happy that it ended up proper in a proper way.
Mm-hmm.
Title was discharged and transfer was done, and everybody is happy, right? But except for situations that are like that, which are exceptional, right? Lawyers should really avoid conflicts of interest in general, and especially in representing the two parties in a transaction.
Mm.
And
Thank.
that the lawyer finds himself before the GLC for that, or being sued for professional misconduct.
Mm. Is that a common practice?
No,
Good.
it's not a common practice. Um, it does happen. It does happen. Um, I would say because parties try to avoid paying legal fees, so they prefer to try and get around
Mm.
with a lawyer. And they would say, oh, you have your lawyer? I will use your lawyer, right?
To cut costs.
To cut costs. The party who does not wish to use a lawyer, right, does not have to use a lawyer,
Mm-hmm.
right? So I cannot say that I'm going to deal with you if you're not using a lawyer. But I know that if I am purchasing property and you don't have a lawyer, I am not sending my client's deposit to you,
Mm-hmm.
right? Because if and when you decide that you have a change of mind, or if something should happen to you, that fund that I give you becomes part of your estate. And I have to wait on administration to get it back from my client, right? So it is never a good thing to really conduct a real estate transaction without a lawyer, especially when you have part payments going through the process. So, it's one of the pitfalls.
Okay. I
Yeah.
wanted to ask, in the event that you're my attorney and I sent you my deposit and something went awry, you did some misconduct, how would I get my monies back?
Well, I
I
don't
have to
want to
go to the
speak.
I have to go to the courts?
Well, typically, it's a breach of my fiduciary duty.
Mm-hmm.
It's a breach of trust, and it'd be a breach of my engagement with you.
Mm-hmm.
So you would have a recourse in court. You also have a recourse to the same general legal counsel.
Mm-hmm.
And that last instance, I'm not sure that the fund is yet up and running, but one of our seminars for professional development that we had spoke to a compensation fund where clients who suffered losses because of the missteps of attorneys can make a claim on that fund.
Mm-hmm.
There is a limit. You may not get back everything, but there is a limit,
Okay.
right? But that is why it is important, as I said, that your attorney is an established attorney with reputation
Mm-hmm.
who has
Very
something to prove.
important.
Because, for
Yes.
example, if I should take your money, there's no way for me to run and hide. Because anywhere I run and hide, people are going to know me,
Yes.
for example.
Yes.
Yeah,
Yeah.
so it's very important. There have been instances where the client can't find a lawyer.
Mm.
The lawyer migrate and gone,
Wow.
so you have to be very careful.
Yes,
Yeah,
indeed. As those are costly mistakes, real estate transactions and the processes and the fees and so on, they are costly. And on
right.
that note, other than the
And it's
deposit,
important to know that when you give monies to an attorney, always ensure you get a receipt, right? And always ensure that you get what you call a statement of account that shows what has been done with your money, right?
mm-hmm.
So that can be the source of your claim.
Okay.
Everything goes all right.
Okay, thank you for that. So other than the deposits, are there any other legal fees that are associated with real estate transactions?
And when you say legal fees, I mean fees to the attorney
Fees to the
or,
attorney,
or
yes,
fees for the
and fees for
transaction.
the transaction.
All right. So for the transaction, I would have outlined before
Yes, a few of
that you
them.
have the transfer tax, which is 2%, and you have the stamp duty is a flat $5,000, which is shared equally by both parties. And you have the registration fee, which is 0.05%, also shared equally, right? You have other fees, legal fees, of course, for the lawyer's work,
Mhm.
and also half costs for the preparation of the sale agreement. Some lawyers charge GCT on its fees. These are fees, some do not, right? I think that is where it depends on where they fall in the tax code, if they reach the threshold to charge GCT. You may have property taxes because a property is not going to complete conveyancing, meaning transfer from one party to another.
Mhm.
Property taxes being outstanding.
Whose responsibility is that to clear
The vendor.
those? Okay.
The vendor's responsibility to clear all property taxes, all debts that run with the land,
Mhm.
property taxes,
Water. Mhm.
and then water. Now it's important because it's important that you get the water situation right because never you rely on the vendor to tell you what is the outstanding amount on the water,
Mhm.
right? Even if you're seeing a bill, it is best to make a check with the Water Commission yourself to ensure that what is outstanding you have covered because the worst thing you can do is to pay out those proceeds to the vendor. And then there's a water bill on the property that you never discovered, especially if it is very high, because the vendor more than likely is going to not want to pay it
Mhm.
because they've already given him the proceeds.
Mhm.
So it's best to check the water. The NWC has a system where you can pay for a search, a proper search,
Mhm.
and they will give you an indication as to what the water is, what the water bill is. You'll go to the land, you will see a flat land, no building on it, and you assume that there's no water on it. Never do that, because there could have been a disconnection years ago for non-payment of bills. And when you having purchased that land, when you decide to connect water on it, and the rest is say no, yeah,
Very-
$400,000 outstanding for
Wow.
water, right? And you have to pay it. You have to be very careful about that.
Wow.
Right? There are some things I said that touch and concern the land, and it is important that the attorney and the client and especially the purchaser
Mm-hmm.
is aware. There's a term in law that we call caveat emptor.
What is that?
Caveat emptor, let the buyer beware.
I see.
It is a duty, the buyer has a duty to check what he's buying and ensure that it is intact. And that is why we have things like surveyors. We use surveyors a lot in our transactions
Mm-hmm.
to ensure that what is on the ground is really what we are buying and it accords with the title.
What are closing costs or closing fees?
Oh, closing fees. Wow. Well, I would think that those are fees that are, as they say, that you have to pay to close the costs, right? Now, at the last end of a transaction would be the registration fees, right?
Mhm.
And of course, the statement of account will show that you pay the realtor's fees, you pay the lawyer's fees, because the lawyer typically is not going to take any money from your deposit until the transaction is completed. You should not be taking money out of it and saying, oh, I'm taking my money up front. No,
Okay.
right? Some attorneys who represent the purchasers would take their money up front because they are not handling any funds in the transaction,
Mm-hmm.
but take their money up front. But closing costs are typically the cost that you pay to close the transaction. Now the bank as a quote unquote closing fee, especially when you're doing a mortgage, right? The bank has its own costs. And I've seen a transaction just the other day where the person was borrowing about 16, $17 million from the bank. And they were paying bank fees of nearly $1 million.
That's the same as the processing fees?
Processing fees
Wow.
and the fees to do the stamping of the mortgage and so forth.
Mm-hmm.
So those are coming up to close to 20%
Wow.
of the
Purchase price.
yes, because when I saw $800,000 and change for a $19 million mortgage,
That's a lot.
that's a lot. So persons who are taking a mortgage need to ensure that they have that covered
So
because
on
the
that,
bank, yes.
sorry. So on that note though, so because typically persons are aware that they need to pay the 10% deposit, but I find that a lot of persons may not be aware of closing costs and the other costs associated with real estate transactions. So what percentage would you recommend that persons have at least this amount set aside before walking into a transaction?
Um, in terms of setting aside, I know deposit, deposit would be 10%, and you probably have another 10 to 15% aside that you need to have.
So 25%?
And if you're taking a mortgage,
Mm-hmm.
right? But if you're just buying the property cash, your 10% should be able to cover your government fees and your legal fees.
Okay.
Issue comes up now when you have a mortgage. And I said that I'm seeing that, and I would ask the vendors to shop around for processing fees. So because many persons shop around and look for interest rates Sometimes the mortgage companies with the lowest interest rates have high processing fees. So you have to try and get a bang for the buck. And never you, as a purchaser, fear negotiating.
Mm.
You can say to a bank, I'm getting 7% here.
Mm-hmm.
You need to beat that. And some banks will try and beat it. So
Mm-hmm.
you don't have to accept the rate that the bank says, the interest rate. You can negotiate, right? And
Mm-hmm.
sometimes when you can negotiate to the point where the fee, the interest rate is a particular percentage. But when you have a little now space in your income now, it can go back to what is market. So the bank can give you a graduating interest rate scale. So those
Mm.
are things that you can negotiate. And with an attorney who's assisting with the negotiation, you can get assistance with that.
Mm. Okay. I don't think a lot of persons are aware. You just tend to take whatever rate that the bank has prescribed. You didn't know that you had the flexibility or the room.
Well, like anything else, you have to shop around.
Yes.
As I said, you have to shop around because it is a competitive environment. And when a bank books a mortgage, it's a big thing, right? So they don't want to lose that mortgage, and they sometimes will meet you close to where you are to ensure that they get that business.
Yes. Yes.
Right.
All right. So switching gears a little bit as it relates to tenancy. So in terms of two persons purchasing a property, whether husband or wife or siblings, can you advise on the types of tenancy involved?
Well, the typical tenancies in Jamaica would be joint tenancy, which is the purest form of tenancy, and the tenants in common regime. Now, for joint tenancy, usually recommended where persons are married, and they're in a connected relationship and they have children, that you have that kind of tenancy that really carries what we call the right of survivorship, which means that the survivor takes the land where one party dies, right? And the joint tenancy
Mm-hmm.
is a situation where the law has an interesting nomenclature because they see both persons as owning the land 100%.
Mm-hmm.
You have 100% and you have 100% because we are jointly tenanted. We are equally in the ownership, right? And I typically cannot do and should not do anything to dispossess the other person. So joint tenancy is in its purest form, whilst you're alive, is a benefit. Both of us have to approach and deal the property in a common way, right? Remember an instant where there are two persons in joint tenancy and one rented the property without the permission of the other. And it became an issue because it's as much you're joined at the hip,
Mm-hmm.
right? In joint tenancy. Um, and that is where the bonds and the relationship are strong. If you don't have that, then the best thing to do is to do a tenants in common, right? And that means that each person has divided shares, right? Whether equally or in fractions, right? And many persons, somebody asked me today, how many persons can be on a title? And I say as many as possible,
There's no limit.
right? Typically, no,
Mm.
right? Because as long as you can fractionize a title,
Mm-hmm.
1/8 or 1/16 or 1/32.
Mm-hmm.
Now I need to be counting. Once the denominator is getting larger, the fraction is getting smaller,
Mm-hmm.
right? And that is something that but I certainly would hope that if persons are doing tenants in common, you're not putting 3,000 people on a title. Yeah, if I'm seeing, for example, more than 6 or 8% of title, I'm getting concerned,
Mm.
right? But the norm is 2 or 3. When the NSC, for example, had the system where 3 persons can join to buy,
Mm-hmm.
but a lot of that.
Yes.
3% title. I think that still is the case. But typically for co-ownership, it's 2 persons, typically. And then now you can own property in different ways. For example, one person can be a life tenant, and the other persons can be remainder men, what we call remainder men, right? For example, a mother can hold a life tenancy in a property, and the children are remainders. So it means they can only take the property when the mother dies,
Mm-hmm.
right? And many times you do that because the children does not have capacity to take and control land, right? And so the mother will hold it, or the father will hold it, and when the children becomes capacitated,
Mm-hmm.
they can now take their share.
Would that need to go through probate, given that their names are already on the
No,
title?
there's no probate in that regard.
Okay.
It's just
Oh.
what we call a note death
Mm-hmm.
of the death on the
Mm-hmm.
title, but you still have to go through the stamp duty process
Okay.
on the estate. You don't just take a death certificate to the titles office and say, note the debt on it. You
Mm-hmm.
want to ask what we call a Form 8, show
Mm.
that estate duties have been assessed before they do that, right? But you don't have to go to the court in that regard.
Mm. Okay. All right. So on the note of property protection, I think a lot of persons are concerned, especially persons in the diaspora who own properties in Jamaica, the matter of adverse possession. Can you explain what exactly is adverse possession and how one can protect themselves from being adversely
But
possessed?
adverse possession is a very hot matter. One counselor friend of mine years ago called matters like these hot matters.
Mm-hmm. Mm-hmm.
And I've heard legal advice on it. So there's a colleague of mine who was on television the other day, and he spoke quite eloquently about adverse possession, and it created a firestorm.
Yes, I can imagine.
Adverse possession is simply where somebody sits on your land or lives on your land or controls your land for more than 12 years without any molestation, exclusively and openly indicating to the world, to the reasonable man, that he is in control of it. And the true owner, in that instance, has vacated his right to legal title. So what the true owner would have is the paper title,
Mm-hmm.
but the physical possession would now be with the adverse possessor. And that happens typically when the owner abandons his property, doesn't come on the property, doesn't pay the property taxes, doesn't take control in any way of the property. Now, the adverse possessor can only adverse possess if he went onto the property without permission. If
Mm-hmm.
at all he went onto the property with permission, right? He cannot adverse possess the property.
How is permission granted? What if
Maybe
I
maybe
go
maybe went there
further?
as a tenant, right?
So what if I have a family member and I just maybe I'm overseas and I ask someone to just, stay in the house instead of having it vacant. But 12 years has passed. I didn't charge them any rent, anything like that. It wasn't a written contract to say, I'm granting you permission to keep and
Well,
care.
if you can lead evidence successfully in a claim for in an adverse possession claim,
Mm-hmm.
if you have a witness who heard you say that, or
Mm.
if there's any dealings, for example, through WhatsApp messages or email, the conversation will be such that the person knows that you have not abandoned your interest. um, even though he didn't give them a rental agreement,
Mm-hmm.
permission can be adduced from that. And once permission is adduced, then the person is not in adverse possession at all. You know, what people typically do in instances like these is to um, give a lease with what we call a peppercorn rent,
Mm-hmm.
where the person pays a symbolic $1 or
Mm-hmm.
$10. And the terms of years are outlined in the lease. And that typically protects the landlord, the owner, sorry. Now the owner has to still maintain his or her obligations to pay property taxes, right? And if it is that time is running, you should notice this. And sometimes you see properties, especially vacant lots, they are fenced.
Mm-hmm.
There's a posting on it, trespassers will be prosecuted. That is an owner protecting his land,
Okay.
adverse possessor, right? So if you leave your land, don't clean your land, you abandon the land, and other people start to do it, and they do it for 12 years, you are at risk of losing your property.
So paying the property taxes alone is not enough. That's what you're
Not,
saying.
it is not enough. You must be visiting your property. You must be showing control over your property. And if you have someone on your property, those persons must be on it with your permission, right? If they are hostile towards you, you get them off using the court through the court. You don't let them stay on it because open hostility against you as the owner, if it prolongs after 12 years, it's a clear case of adverse possession.
How difficult is it to remove, would you call that person a squatter? How difficult is it to remove that person? So if I have property here, I live overseas, I've been overseas for 5 years, I come back to visit the land and I realize that there's a structure on it without my permission. And I'm going through the courts. Can you just walk us through what that process may look like? How long will it take and such like that?
Well, well, the the first thing to do is to issue a notice
Mm-hmm.
to the person that is on your land. And typically, we ask them to leave within a month
Okay.
of the notice date, right? And it is because that is because normally rent is paid monthly.
Mm.
Same though the person not paying your rent, a reasonable time for them to leave is a month. So you give them notice to vacate the premises. If after a month they have not left, then you have a right to take out what you call a summons in our parish court, in any one of our parish courts,
Mm-hmm.
and where you live. For example, if it's Kingston and St. Andrew, you're going to be finding that action in the Sutton Street civil parish court, right? And you start, but you can go down, any Jamaican can go down there. They don't even need a lawyer,
Mm-hmm.
right? But it is best always to
Mm-hmm.
get a lawyer to assist you. But many persons go without an attorney, and the staff can help them to complete the parties of claim, right? And I think within 7 days or so, you can go for the summons. And then you summon the person, serve the summon on the person on your land, and the summon would indicate a court date. Have them before the court. Once it is that they cannot show any reason, lawful reason why they should be on the property, then the court usually order, orders them to give up possession of the property.
Mm-hmm.
And
So
if
first,
they fail, they're subject to eviction.
so it's not advisable for persons to take matters in their own hands and try remove
No,
that person.
self-help is always something that can get you into trouble, right? Because as I said, there is a process, a judicial process.
Mm-hmm.
If you decide to burn down house or take bulldozer and lick down house,
Mm-hmm.
beat people, you can find yourself on the wrong side of the law, the criminal law, right? And you can find yourself on the wrong side.
Mm-hmm.
So it is best to use the court system and be patient.
So what if I'm overseas? Can someone act on my behalf?
Yes. Now, somebody can act on your behalf, as I indicated before, through a power of attorney. The power of attorney, it's a critical document that one can use when he or she is overseas. And that empowers someone of legal capacity to act on your behalf. Now, that power of attorney has to be stamped for it to be valid, and then it has to be stamped within a year of execution. Many people do not know that.
Mm-hmm.
Have your power of attorney stamped for years sitting down and think you have a power of attorney. And you don't, because it lapses because it has not been stamped within a year. So you stamp it with your $500 stamp duty and you record it at the Island Record Office. And at that stage is given a volume and folio number, and it is duly recorded. Now, if you're going to engage the titles office to transfer property or to lodge caveats or anything on behalf of the landowner, then that it also has to be recorded at the titles office
Mm-hmm.
and accepted. And there are times when the titles office reject powers of attorney. So the power of attorney has to be crafted properly. We talk about certainty in wills. There's certainty in power of attorney because you're giving the person authority to act on your behalf. The powers have to be delineated in a cogent way, which is clear and void of ambiguity.
Mm-hmm.
It has to be um, as specific as possible and as general as possible where needs be, so that the the what we call the attorney in fact, which is the person who is the receiver of the power, can act without any any hindrance in executing on your behalf. So the power of attorney could say that my attorney, in fact, can bring legal action on my behalf, can recover funds, can pay
Mm-hmm.
out funds, can hire attorneys, can hire accountants. All of those are powers that you give. And it speaks to in respect of what property. If it's a motor car, if it's land, you give the volume and folio number. You give the description of the land so that anybody who is dealing with this person on your behalf would know that you have given this person the power, and the powers are as specific as possible. Once you have the power of attorney, you can act in the stead of the person abroad, and it includes issuing notices to persons who are on your land. You can um, implement a rental system if you want to keep them there and they're willing to pay rent,
Mm-hmm.
right? You can remove them through the courts, bring an action in the courts against them. Some powers of attorney allow you to sell the property,
Mm.
right? Or
Okay.
to lease the property. But the power of attorney or the POA or the attorney, in fact, must not be using the power for him or herself. They are exercising the power on behalf of the grantor of the power or the donor of the power, which is the landowner, in this case, who is living overseas.
Mm.
So the power of attorney must not be making secret profits because there's a breach of trust issue that you can have there. So powers of attorney must ensure that they know that they have entered into a fiduciary relationship with the owner of the property, who can sue them for breach of trust and
Mm.
profits in that regard. But that's one way of protecting your land, and members in the diaspora can find people who they trust. They can even ask a lawyer to be a power of attorney.
Mm-hmm.
But remember again that if the lawyer is a power of attorney, the lawyer cannot act for himself. You'll have to get another lawyer.
Right,
So
right. For the
that,
transactions.
that,
Mm.
there's
Okay.
one thing that I didn't speak about when it comes on to executorship. So
Yes.
to testamentary gifts now.
Mm-hmm.
Um, the executor, I must tell you by law, um, is required to receive 6% of the estate.
Oh, yes.
Yes. And so when you choose your executors, some people, I remember I have a case where the bank was the executor.
Mm.
The bank, a commercial bank, was the executor, right? And through negotiation, we got the bank to renounce because a commercial entity like that will want their 6%,
Yes.
right? But that takes money away from the beneficiaries.
Mm-hmm.
So you want to use an executor who is going to have some conscience
Mm-hmm.
and not take a lot of money for themselves, but ensure the beneficiary gets as much funds as possible. Even though administering and distributing a property is hard work, right? But you really would want somebody who would forego, would be doing that as a favor
Mm-hmm.
for you as is our friend
Mm-hmm.
when you have passed, rather than somebody grabbing funds out of your estate. So I just wanted to make that point.
Yes, and thank you for that. That's a much needed point to consider. I know in Jamaica, real estate transaction can take anywhere between 3 months up to a year. Um, in terms of the new, because I know we are improving, so I know that there's a new digital titling process. How do you see this process impacting real estate transactions?
Well, um, we are in the age of artificial intelligence,
Mm-hmm.
and law and the real estate market and the real estate transactions are not immune to that. The faster you can move title, the better it is for everybody, because I've seen too many clients frustrated when there are glitches in the system.
Mm-hmm.
So if the steps are clearly delineated and outlined, and you can have a system that tells you real time that you have an error here, an error there, or you miss a step here, then that will always be great for the market. And quicker turnaround time means less cost and better efficiency, and that should see an increase in economic activity and redound to the benefit of everybody. So I welcome that.
Yes, yes. My final question to you, other than real estate transactions, are there any other matters that you are involved in that persons can reach out to you for if they need your services?
Well, you know, I will answer this way. I'm hoping that we are not training half and quarter lawyers in Jamaica. So the lawyer typically should be a wholesome lawyer
Mm-hmm.
who can touch and concern himself in all areas of law. However, some attorneys specialize, right? For me, the matters of conveyancing, probate practice, and family law, those are matters that I typically find myself involved in. I certainly would have a challenge doing criminal matters. I don't do criminal matters. And I don't ordinarily take up divorce matters either,
Mm-hmm.
right? Unless I am properly seeing that it is a proper thing to do. There is a, 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 a Bible verse that says, "Who God put together, let no man put asunder."
Yes.
So I'm very careful about
Yes.
pulling people apart. But the matters that I have done for family law are those particularly where the people have been separated for like 10 years, and they have formed other lives. They have gone on to have other children with other people, and they just need to just formalize what they have done.
Mm-hmm.
You know, those matters are always stressful matters. The other matters that are hot, I would ask the clients to go and get counseling
Mm-hmm.
and ask the counselor to tell me whether or not there's a likelihood of cohabitation, of them getting back together. And sometimes I typically ask a pastor to talk with them and to see, if the marriage can be saved. I think it's better to save a marriage than to divide it. So
Agree.
it's a technical area that I am, I would only touch where certain things are in place, but not just willy-nilly. Some lawyers say, well, they want divorce them. I'm not like that. But I do touch that as well. Probate is a part of the practice that is heavy as well.
Mm-hmm.
And that is also a very tricky area, as I said,
Mm-hmm.
and family members are grieving over their loved ones, and sometimes it creates instability and it creates conflict, just that a loved one has been lost. And so you approach that with a kind of sensitivity,
Mm-hmm.
to protect the family, to counsel the family, and to take them through. It's an area. With some commercial work too, in terms of setting up of companies, um, deal with issues of compliance with the Companies Act and so forth.
Okay.
Yes, so those are
That's
particularly the areas.
a full shop, a full
Well,
suite.
well, yes, and you have to ensure that where you are obligated in your 9 to 5,
Mm-hmm.
you have to ensure that you are not cross-cutting.
Mm-hmm.
So you have to manage your time well, meaning that I get less sleep, less than the ordinary
I can
number of hours
imagine.
of sleep.
I can imagine.
But I do have a partner who carries some of the weight as well.
Mm-hmm.
Um, that helps.
Okay.
Right? As I said, the firm is Ferguson Bernard and Associates. So there is a Ferguson
Oh, yes, yes, yes,
with
yes.
me,
So that helps to
right?
balance
So that
everything
that
out.
helps, right, right.
All
But
right.
as I said, the practice of law is something that stays with you until you are dead. I know lawyers who are practicing now in their 90s.
Oh.
So it's not a profession that you retire from, typically.
Mm.
Uh, so to me, it's one of the best professions to have. And I'm sure that many persons will say that, right? It requires honesty. It requires having a conscience, and requires respect and love for people, especially your clients. And what I try to tell people all the time, even if you don't have the answer that a client wants, always respond to them. Always ensure that you're available to them.
Mm. So what's one piece of advice you would give to persons who are purchasing properties?
Well, one piece,
One piece as we wrap up.
get enough information on what you're buying and seek legal advice at the beginning of your transaction.
Enough said. All right. I want to thank you, Mr. Bernard, for taking the time out of your busy schedule to share with us here on Hooked on Real Estate. I so appreciate your insights and all the nuggets that you dropped on us this afternoon. So appreciate you. Before we close, I just want you to mention again the name of your company and to provide your contact details for those who may want to reach out to you for your services.
All right. Well, thank you too for the discussion. I think that it was, for me, very engaging. And
Yes.
you clearly did your research. You came with some pointed questions.
Mhm.
Sometimes when you ask them, I feel like I want to run away. But I feel that I stood up
Mhm.
and I answered to the best of my ability. I am not providing advice, legal advice to anyone
Mhm.
that is listening. This is not an advisory program. I'm not engaged, so I'm not providing legal advice. I'm just providing general information
Information.
based on my skill and competence. My firm is Ferguson Bernard and Associates. We're at 22B Old Oak Road, Kingston 5. My email address is burnslaw@gmail.com. gmail.com.
Do you have a contact number you would want to share?
Just contact me by email.
Via email. Okay.
Yes.
All right. So I will leave that
You
information
find
as
that the phone
well.
can blow up. You don't want it to blow up. So just
Understandable.
contact me by email.
Understandable. So I'll leave your email address and the name of your company for those who want to reach out to you for services. Again, I thank you so much.
You are most welcome and congratulations again. And I wish you success as you maneuver.
Thank you.